Article 2, Application of its Provisions. Revised Penal Code of the Philippines by Luis B. Reyes. Article 2, Application of its provision, except as provided in the treaties and laws of preferential application, the provisions of this code shall be enforced not only within the Philippine archipelago, including its atmosphere, its interior waters, and maritime zone, but also outside of its jurisdiction against those who, number one, should commit an offense while on the Philippine ship or airship. Two, should forge or counterfeit any coin or currency note that of Philippine Islands or obligations and securities issued by the government of the Philippine Islands. Number three, should be liable for acts connected with the introduction into these islands of the obligations and securities mentioned in the preceding number. Number four, while being public officers or employees, should commit an offense in the exercise of their functions, or five, should commit any of the crimes against national security and the law of nations defined in Title 1 of Book 2 of this code. Scope of the application of the provisions of the revised Penal Code. The sovereignty of the Philippines extends beyond its land, territory, and internal waters, and its archipelagic waters, to an adjacent belt of sea described as the territorial sea. This sovereignty extends to the airspace over the territorial sea as well as to its bed and subsoil. Under Article 2 of Section 1 of United Nations Convention on the Law of the Sea, or UNCLOS, the breadth of the territorial sea is 12 nautical miles from the archipelagic baseline. So the provisions of the RPC shall be reinforced not only within the Philippine archipelago but also outside of its jurisdiction in certain cases. The 5 paragraphs of Article 2 treat of the application of RPC to act or acts committed in air, at sea, and even in a foreign country when such acts affect the political or economic life of the nation. So in what cases are the provisions of the revised penal code applicable even if the felony is committed outside of the Philippines? So they are applicable in the following cases. 1. When the offender should commit an offense while on the Philippine ship or airship. A Philippine vessel, although beyond 12 nautical miles from the archipelagic baseline, is considered part of the national territory. Thus, any person who committed a crime on board a Philippine ship or airship while the same is outside of the Philippine territory can be tried before our civil courts for violation of the penal code. But when the Philippine vessel or aircraft is in the territory of a foreign country, the crime committed on the said vessel or aircraft is subject to the laws of the foreign country. A Philippine vessel or aircraft must be understood as that which is registered in the Philippine Bureau of Customs. It is the registration of the vessel or aircraft in accordance with the laws of the Philippines, not the citizenship of its owner, which makes it a Philippine ship or airship. A vessel or aircraft which is unregistered or unlicensed does not come within the purview of paragraph 1 of Article 2. Thus, if a crime is committed 15 nautical miles from the archipelagic baseline of the Philippines on board a vessel belonging to a Filipino, but the same is not registered or licensed in accordance with the laws of the Philippines, paragraph number 1 of Article 2 is not applicable. The Philippine court has no jurisdiction over the crime of theft committed on the high seas on board a vessel not registered or licensed in the Philippines. Number 2. When the offender should forge or counterfeit any coin or currency, note of the Philippines or obligations and securities issued by the government. Thus, any person who makes false or counterfeit coins under Article 163 or forges treasury or banknotes or other obligations and securities under Article 166 in a foreign country may be prosecuted before our courts for violation of Article 163 or Article 166 of the RPC. Number 3. When the offender should be liable for acts connected with the introduction into the Philippines of the obligations and securities mentioned in the preceding number. The reason for this provision is that the introduction of forged or counterfeited obligations and securities into the Philippines is as dangerous as the forging or counterfeiting of the same to the economical interest of the country. Number 4. When the offender, while being a public officer or employee, should commit an offense in the exercise of his functions. The crime that may be committed in the exercise of public functions are direct bribery under Article 210, indirect bribery under Article 211, frauds against the public treasury under Article 213, possession of prohibited interest under Article 216, malversation of public funds or property under Article 217, failure of accountable officer to render accounts under Article 218, illegal use of public funds or property under Article 220, failure to make delivery of public funds or property, Article 221, and falsification by public officer or employee committed with abuse of his official position under Article 171. When any of these felonies is committed abroad by any of our public officers or employees while in the exercise of his functions, he can be prosecuted here. Number 5. When the offender should commit any of the crimes against the national security and the laws of nations. The crimes against the national security and the law of nations are treason under Article 114, conspiracy and proposal to commit treason, Article 115, espionage, Article 117, inciting to war or giving war and giving motives for appraisals, Article 118, violation of neutrality, Article 119, correspondence with hostile country, Article 120, flight to enemy's country, Article 121, and piracy and mutiny on the high seas, Article 122. Crimes punishable in the Philippines under Article 2 are cognizable by the regional trial court in which the charge is filed. The crimes committed outside the Philippines but punishable therein under Article 2 of the RPC shall be cognizable by the regional trial court in which the charge is first filed. Rule 110, Section 15D of the Revised Rules of Criminal Procedure. Important words and phrases in Article 2. Number 1, except as provided in the treaties and laws of preferential application. This phrase means that while the general rule is that the provisions of the RPC shall be enforced against any person who violates any of its provisions while living or sojourning in the Philippines. The exception to the rule may be provided by the treaties and laws of preferential application, like the RP, Republic of the Philippines, and US. Visiting forces accord the military bases agreement between the Republic of the Philippines and the United States of America and the provision of RA number 75. Number 2, its atmosphere. The sovereignty of the subjacent state, and therefore its penal laws, extend to all the airspace which covers its territory, subject to the right of way or easement in favor of foreign aircrafts. Number 3, interior waters. The phrase interior waters include creeks, rivers, lakes, and bays, gulfs, straits, coves, inlets, and roadsteads. Under Section 1 of Article 8 of UNCLOS, waters on the landward side of the baseline of the territorial sea form part of the internal waters. Number 4, maritime zone. Maritime zones includes the territorial waters of 12 nautical miles from the baseline. Contiguous zone is 24 nautical miles from the baseline. Exclusive economic zone is 200 nautical miles from the baseline, and continental shelves. It is based on Magalona versus Ermita of GR number 187167 of August 16, 2011. Crimes committed on board a foreign merchant ship or airship. Just as our merchant ship is an extension of our territory, foreign merchant ship is considered an extension of the territory of the country to which it belongs. For this reason, an offense committed on the high seas on board a foreign merchant vessel is not triable by our courts. Continuing offense on board a foreign vessel, but a continuing crime committed on board a Norwegian vessel sailing from Formosa to the Philippines by failing to provide stalls for animals in transit in violation of Act number 55 is triable in the Philippines. The offense of failing to provide suitable means for securing animals while transporting them on a foreign ship from a foreign port to a port of the Philippines is within the jurisdiction of the courts of the Philippines. When the forbidden conditions existed during the time the ship was within the territorial waters, regardless of the fact that the same condition exists when the ship sailed from the foreign port and while it was on the high seas. Rules as to jurisdiction over crimes committed aboard foreign merchant vessels. There are two rules as to jurisdiction over crimes committed aboard merchant vessels while in the territorial waters of another country. The first is French rule. Such crimes are not triable in the courts of that country unless their commission affects the peace and security of the territory or the safety of the state is endangered. 2. English rule. Such crimes are triable in that country unless they merely affect things within the vessel or they refer to the internal management thereof. Under UNCLOS, the criminal jurisdiction of the coastal state should not be exercised on board a foreign ship passing through the territorial sea to arrest any person or to conduct any investigation in connection with any crime committed on board the ship during its passage, except, first, if the consequences of the crime extend to the coastal of state. 2. If the crime is of a kind to disturb the peace of the country or the good order of the territorial sea. Number 3, if the assistance of the local authorities has been requested by the master of the ship or by a diplomatic agent or consular officer of the flag state. Or 4, if such measures are necessary for the suppression of illicit traffic of narcotic drugs or psychotropic substances. However, the coastal state has the right to take any steps authorized by its laws for the purpose of an arrest or investigation on board a foreign ship passing through the territorial sea after leaving internal waters. The coastal state may not take any steps on board a foreign ship passing through the territorial sea to arrest any person or to conduct any investigation in connection with any crime committed before the ship entered the territorial sea if the ship proceeding from a foreign port is only passing through the territorial sea without entering internal waters under Article 27, Section 1. So, do the Philippine courts have jurisdiction over the crime of homicide committed on board a foreign merchant vessel by a member of the crew against another? These orders which disturb only the peace of the ship or those on board are to be dealt with exclusively by the sovereignty of the home of the ship. But those which disturb the public peace may be suppressed, and if needed, the offenders punished by the proper authorities of the local jurisdiction. It may not be easy at all times to determine to which of the two jurisdictions a particular act of disorder belongs. Much will undoubtedly depend on the attending circumstances of the particular case, but all must concede that felonious homicide is a subject for the local jurisdiction, and that if the proper authorities are proceeding with the case in the regular way, the consul has no right to interfere to prevent it. Extraterritorial application of Republic Act number 9372. Republic Act number 9372, otherwise known as the Human Security Act of 2007, which was passed into law on March 6, 2007, has extraterritorial application. Section 58 of Article number 9372 provides that subject to the provision of an existing treaty of which the Philippines is a signatory and to any contrary provision of any law of preferential application, the provisions of the act shall apply to 1. To individual persons who commit any of the crimes defined and punished in the act within the terrestrial domain, interior waters, maritime zone, and airspace of the Philippines. 2. To individual persons who, although physically outside the territorial limits of the Philippines, commit, conspire, or plot any of the crimes defined and punished in the act inside the territorial limits of the Philippines. 3. To individual persons who, although physically outside the territorial limits of the Philippines, commit any of the said crimes on board a Philippine ship or airship. 4. To individual persons who commit any of the said crimes within any embassy, consulate, or diplomatic premises belonging to or occupied by the Philippine government in an official capacity. Number 5, to individual persons who, although physically outside the territorial limits of the Philippines, commit said crimes against Philippine citizens or persons of Philippine descent where their citizenship or ethnicity was a factor in the commission of the crime. And number 6, to individual persons who, although physically outside the territorial limits of the Philippines, commit said crimes directly against the Philippine government.